When you hear that judge read the note where this jury is saying we are hopelessly deadlocked, is there any explanation in your mind why they didn't submit a partial verdict? Hey, we are unanimous on some of the charges, but there's just one where we are hopelessly deadlocked.
The form may have been confusing, but they clearly knew how to ask questions, and they clearly were articulate with their feelings and thoughts in their notes. So I don't know why they didn't just say, look, we agree as to count 1 and 3 that she's not guilty. Had they done that, we would be having a different conversation.
So I think the first thing we have to remember is that the jurors, no matter how intelligent, are lay people. So this is new to the group, at least.
The final piece of this puzzle is in place to explain this grossly incompetent investigation into John O'Keefe's passing, the reasons they charged Katen Read, the reasons this thing went to trial with those charges, and the reasons this will go to trial again. So welcome to the point. Let's get to it.
Copyright disclaimer under Section 107 of the Copyright Act 1976. Allowance is made for fair use for purposes such as criticism, comment, news reporting, scholarship, and research. Fair use is a use permitted by copyright statute that might otherwise be infringing. Nonprofit, educational, or personal use tips the balance in favor of fair use.
That means they completely didn't believe what Trooper Joe Paul had to say about the speed and about the distance. Your thoughts?
Well, that's the pickle the Commonwealth's going to be in, right? Or the court, or a higher court, and I agree, it's going to be a higher court that makes this decision. What they have to kind of do is pivot from she wanted to hit him, she meant to hit him, and she hit him to, well, maybe this was an accident. And look, in anywhere else in the world, this would be a case that would resolve itself with a negotiated plea. That's not going to happen in this case.
So, Janae, let me say, and I've said this from the first day at opening statements with Vinny, this case is overcharged. There was no second degree to be had here.
The motion to dismiss is right around the corner, but listen, enough is enough here. And don't think I based any of this on social media or mainstream media, because I started this trial blind just like a jury would. And I listened to the trial as it was presented. And if fair coverage and an open conversation is something you prefer, subscribe to this channel and hit that like button down below. Because if you lay all this out, just the facts of the case, obviously MSP should be ashamed. Canton PD should be ashamed. The Norfolk County DA's office should be ashamed. And the people of that county should be furious because they're going to have to flip this bill if and when Katen Read decides to sue. Since no one seems to be interested in seeking justice for John O'Keefe, they just want that sweet, juicy conviction to pad their resumes. And none of this really made sense to me until very recently, and here's why. First, look at the timeline of a couple of things, since timing is everything. In January of 2022, John O'Keefe passes away. And I don't care what's floating around online, that was a good man. He served his community and his family. On January 31st, the autopsy was complete, claiming blunt force trauma and hypothermia as the reason he passed, with no obvious signs of a struggle or a fight. It was in February that same year Trooper Proctor sent those group text messages that no one seemingly knew about. And I know we know about it now, but for the purposes of this timeline, that's hidden right now. Fast forward to May, when the defense raised their theory that this was somehow a setup or a frame job, and they asked for help from the court, but little is received. On March 12th, we found out that an investigation headed by the FBI has led the defense team to an expert who very clearly proves a car didn't hit John O'Keefe. But no one can know that that third party is the Department of Justice and the FBI at trial. Now on the 1st of July, a mistrial is declared and Trooper Proctor is relieved. A lot happened on the 8th of that month because you had your first motion to dismiss and Trooper Proctor was suspended without pay. 2 days later, on the 10th of July, another juror came forward saying they voted not guilty for counts 1 and counts 3. On July 22nd, an anonymous juror spoke with WBZ-TV and said they didn't know they could relay this information to Judge Bev. And while every creator is talking about these verdicts and what should happen and what could happen, we were also wondering why all of a sudden the Norfolk County DA's office got quiet. Why haven't they been contacted by a juror? And it all comes together as Lally slithers out of his little hole allegedly and files his motion on August 2nd, And not only did we find out that he had voicemails on the 21st and the 22nd, he sent emails on the 16th, and his words to that juror make it all perfectly clear in my own opinion. You see, the defense has been contacted, and they've been doing everything within their power to ensure that these anonymous jurors remain anonymous. And of course, that's not something anybody can guarantee, especially in this case. But Lally gives the impression, hey, if you come talk to me about this case, your name's going to get out there. Now, he's right to a degree. There are certain things he can't talk to any of these jurors about. But did you vote guilty or not guilty is not one of those things. It's almost as if he decided he'd rather not know it all than know the truth. Now, I'm no expert, and everything said on this channel is alleged or speculation. I encourage everybody to do their own research and form their own opinion. But to me, those words tied everything together. We can all agree that in a normal trial, the prosecution lays out all this evidence pointing to one person, and they make the case all throughout the trial. Person X with this item did this to that victim. And then they tie all sorts of circumstantial evidence into their case to reiterate their theories on who did what to who. And the defense tries everything they can to poke holes in various theories and discredit certain expert witnesses. And throughout this trial, and you tell me if you saw this or you didn't, but I saw something odd. I saw the defense on one hand saying this wasn't Katen Read. And I saw the prosecution on the other hand saying who else would it be but Katen Read. Essentially, the prosecution was saying, hey, we got all these people in this home, but it couldn't be any of them. It has to be her. Honestly, at the end of the day, what kind of prosecution is that? It's a complete joke in my own unprofessional opinion. And it seemed obvious to me at that time, and it does even now, that there's a complete lack of accountability going on. And I'm asking the question, why did or why would they do that? One juror has said something to the effect that no one thought she did this intentionally, nor do they believe that she actually was aware she did this. Which of course she wouldn't be aware she did it because the expert said that car did not do that. Now don't argue with me on that statement. That is not my opinion. You can take it up with the guys with the PhDs in physics. Take a look at everything going on in the background. MSPs hiding these text messages to the best of their ability and then hiding Trooper Proctor's punishment until after they see what the verdict is. The court was adamant in not wanting anybody to know that that mysterious third party was the federal government. And Lally said on the voicemail and emails for weeks. It all makes sense now. It's not a conspiracy that happened. It's complacency and a strong push to try to hide this. The Commonwealth simply needs and wants a conviction here because elections and reviews come faster than you think, especially when you're talking about an officer getting passed away. Of course they overcharged in this case. They have no idea who did what, and they certainly had no idea how they could prove it. They just knew it had to be Katen Read, so they slapstick together a whole bunch of charges, threw them up against the wall, and then bombarded the jury with useless testimony, in the hopes that they would just pick something so they could just get a conviction. Because a plea deal from the get-go on a lesser charge looks horrible on a resume. It's speculation, of course, but to me it seems like they're more concerned about climbing a ladder than figuring out what actually happened. If you see it differently, let me know down in the comments below, because this is an open discussion channel at the end of the day. But who's going to stay in power in that area if they blew the lid off some sort of vast conspiracy? Or pointed out continuous missteps by law enforcement? As far as connections go, you have ties to one home of state, local, and federal law enforcement agencies. Of course they would pick on Katen Read. It couldn't have been those other people, it was her. The prosecution has no unions to deal with, no ties to law enforcement, no ties to the community, and no worries about a lack of support. Just forget the science, it was Katen Read. Dropping the first and third count would do nothing but help the prosecution's very weak case. But this refusal to yield is a complete joke. And Katen Read's rights matter more than a conviction. Now we'll see if the judge drops some of these charges on Friday, but honestly I highly doubt it. All we can do at this point is hope and pray that the truth will come out and we get real legitimate justice for John O'Keefe. Y'all be safe now.